Dear Place of Lordship.
Yes.
Today also I may be allowed to move one urgent unlisted motion, Lordship. After the exhausting of the part 1 list or at 2, whichever is earlier, of course, subject to the convenience of your Lordship. This is with regard to the MBBS selection. They have scheduled the date to 4th August.
Okay.
And then I'm challenging the notification.
But the order is very clear, no? Have you seen the order?
Yes, yes.
So, I think everything is there in the order itself.
Everything is there, but thereafter they have issued some orders, which is not in compliance to the Lordship's order. Very unfortunate. So
Okay.
I will satisfy Lordship systematically, Lordship, how they have gone wrong and what the law says. All this I would like to present, Lordship. It will not take
But I
much
have asked them to keep a seat vacant also.
That
Then
has not been done.
they have done that, no?
They have not done.
Okay.
They have issued
No,
revised list.
they may not keep a seat vacant, but they may take up the counseling at least. There are some rules, so I don't know.
Actually, that should be the approach they should have adopted.
Hmm.
Thereafter, they have issued a revised selected list. Who should be called for the counseling? Even in that list, also my name has not been included.
But I have
That
the
means-
but the order is there no, already.
Yes, but they are still under notification of 9/9/2021. I'm challenging that. This is absolutely in contrary to the Government of India instructions. And I'm talking about only the 42 seats, which is meant for the central poll on the basis of the guidelines issued by the Government of India and the state notification which has been
Have you
issued.
you have filed an IA or something?
No, I'm filing a writ petition challenging the notification of 9/9/2021, which is contrary to the Government of India notification. Lordship has already made observation to that effect, but they are going ahead with the attendant attitude.
Actually, I want to recuse from the matter. Yesterday, I got threatening calls. I want to recuse from the matter.
Lordship, that will be a very short matter. I will try to satisfy your lordship.
No, but I got yesterday. I had a very disturbing night. And, I got calls at night in Hindi. Please put up the connection. Put up the connection. Disconnect the video conferencing.
That is very unfortunate.
Yes. Then my suspicion went straight to this issue.
Hmm.
We tracked down the number also. You have disconnected it. Okay.
Dear so and so, as you are aware, the product infrastructure development of tourism destination and circuits scheme has been dealing from the urban support, and the scheme has to be implemented by the state government.
Okay, okay.
State government. Now, I have done the work.
Hmm.
Whatever the miscommunication or the delinking of this project is concerned, that is not my locality of watch. My concern is to construct it. So state has to pay by any means. State has to pay me.
So I think it's not required, I think.
No, Your Lordship, if my Lord can kindly refer to the last page, to the next page, Your Lordship.
Hmm.
No, the blame game is going on. Now the ministry is saying we can ask from the donor. So we don't know when this matter will be settled. This is 2018. And the last communication made by the state is in 2021. We are in 2025. 4 years.
Lordship,
Lordship, I can never see the light of the day at this juncture.
Lordship, if I may be allowed to read this letter to show that the project actually belonged to the Union of India, my Lord.
Okay.
Your Lordship, this is a letter written by the Director General of Ministry of Tourism, Your Lordship.
Yes.
This is to address to the Commissioner, Secretary Tourism Department, Government of Nagaland. As you are aware, Your Lordship, as you are aware, the product infrastructure development for destination and circuit scheme of Ministry of Tourism has been dealing from union support for state plan with effect from financial year 2015-16 after the higher devolutions of 42% of union taxes and UTs to the state on the recommendations of the 14th Finance Commission. Accordingly, no budget allocation with effect from the financial year 2015-16 for the said scheme under the state plan was made available to the Ministry of Tourism. However, Ministry of Tourism and Donia has been persuading Ministry of Finance to allocate funds for the said projects which were in advanced stage of completion. In order to facilitate this exercise, it is imperative to know the current status of all the PIDCC projects which are in advanced stage of completion. That is more than 50% of physical progress achieved on ground. I will appreciate if you kindly send this ministry the requisite information in enclosed proforma so that the ministry can again take up the matter with the Ministry of Finance. So, Your Lordship, the project and the sanction has to be given by them. We agree, Your Lordship. Work order has been issued to us for the fact that the Tourism Department, state government, has been made as a nodal department.
Finally, the funds will come to the
Yes,
state.
it come to form the union. Otherwise, Your Lordship,
No,
we
then
don't have any
funds will
fund.
come to the state.
Yes,
And the state has to
have
pay.
to pay.
But there is no fund allocated.
There is no fund allocation. Your
Even to
Lordship.
the central government.
Yes, we are also communicating to them to make the necessary fund.
No,
But there's a
Lordship,
till date, Your Lordship.
issue now
I
is
think Union of India is not required to be made a party.
yes.
Your Lordship, if that is the case, the project belongs to the Union of India. If they are not releasing the fund, from where will we pay, Your Lordship? At least let the petitioner impede the Union of India. Let them come and say,
Every funding, Lordship, every funding is from the government of India.
Hmm.
For the state. Any
Yes.
project,
Yes.
it's government of India funding. So the money comes.
and the Union of India is admitting that the project has been stopped. After the work order has been issued, my lord. Before the completion of the work, after the work order is issued, the project has been stopped.
They could have informed, the funding has stopped, so not to proceed with the work, but let us work. Lordship, that is the issue.
So as of now, Your Lordship, if the union can be implemented, and I'll file a comprehensive affidavit, Your Lordship, on this issue.
Now, who to implement your Lordship?
The Ministry of Tourism, my lord.
Okay.
Then-
I think they have to be made a party.
Yes.
I think so.
The fourth uniform Lordship
Hmm.
can implement the ministry.
Ministry has to be made a party.
Yes, Ministry of Tourism, my lord.
Yes.
This is their project.
So on that context, you'll file an affidavit.
No, Your Lordship, let them be implemented. I'll file a comprehensive affidavit to the
Lordship,
affirmation made
Let
by
me-
this.
Let them file an affidavit to this effect. This letters bring on record. Then the court can implement the ministry accordingly. Because Lordship, here they are even mentioning the Ministry of Donier.
Hmm.
Now, whether Donier will be a necessary party again, Ministry of Finance again. We have to implement three departments.
Yes.
Ministry of Finance, Ministry of Tourism, and Ministry of Donier.
Yes. No. Tourism is not required. I think.
No, Donia is not, because
As
this
they
is the,
they are making a request to the Donia Ministry.
No,
Keep
no.
funding.
this is the Ministry of Tourism is making this suggestion. That Donia, they are seeking fund from the finance as well as from the Donia.
Okay, you explain it through an affidavit. It will be better
Let
that
them-
way.
Okay.
And the court can buy some.
Yes.
This,
Yes.
It is item number 1.
No, Your Lordship, item 37 and 38, my lord.
Learned Counsel Mr. M. Moju.
Amazon. Yes.
N. Moju is present for the petitioner. Learned Government Advocate Mr. N. Angamini
Lordship.
is present for the state respondents
Yes, ma'am.
and has submitted for time to file an affidavit.
Yes, ma'am. I was actually seeking for implement of the Union of India actually.
And has also prayed to implead the Union of India. Implead the Union of India as a necessary party.
Yes, ma'am.
Okay. List the matter after 2 weeks.
2 weeks, Your Lordship.
Okay, 2 weeks.
And you oblige.
Similar order in item number 38 also. 37 and 8. There are two another.
Yes, 37, 38.
Obligation.
Deeply obligement.
Oh, he's sitting back.
So Lordship, Lordship, I will be allowed to make mention item number 43 from the supplementary list, Lordship.
Mm.
Lordship, I have some personal difficulties today.
Yes.
So if the matter can be taken up on Monday, Lordship. I'm taking the
Can be
consequence.
taken up on Monday.
Uh,
Learned Counsel Mr. N. Muzoi, with the consent of the other side, has prayed for your standing counsel.
Yes, sir.
Learned Standing Counsel Mr. N. Muzoi for respondent number 8,
Eight.
comma, with the consent of the other side has prayed for adjournment. List the matter on Monday. What is Monday? 4th. Okay.
Obligation.
Yes.
Yes, Your Lordship, I'd like to mention here in item number 14, Your Lordship.
14?
40.
Okay, 40.
Okay, yes,
Yeah.
Your Lordship. Since my senior exec is positive, the matter can come up to 2 weeks, Your Lordship.
Learned Counsel Miss
Kim Piana.
Kim Kena, on behalf of Learned Senior, on behalf of our senior Mr. M. Jamil,
N. Longkuma.
Mr. N. Longkumar, with the consent of the other side, has prayed for adjournment. List the matter when do you want?
After 2 weeks. Your
After
Lordship.
2 weeks, okay?
Lordship. Obligation.
Your Lordship, I would like to also mention item number 41, Your Lordship.
Mm.
Since the leading counsel have already applied for leave, if the matter can come up after 2 weeks, Your Lordship.
Learned Counsel Miss
Kim Piana.
Kim Pena,
Yes.
with the consent of the other side. No, oh, the other side is not present, no?
I'm representing the state.
Okay,
here.
okay. With the consent of the state, with the consent of Miss N. Inaholi, Learned Counsel for the state, no?
Yes, Your Lordship.
Government advocate,
Yes, Your Lordship.
Learned Government advocate for the state. Has prayed for adjournment.
Your Lordship, it's the petitioner's counsel. They have applied for leave, so they are seeking adjournment. Your Lordship.
Okay, you have applied for leave, no?
Yes, yes.
Okay. It has been circulated.
Yes, Lordship, it's in the leave note, Your Lordship.
Okay.
To
It is also circulated that the leave for the counsel for the petitioner has also been circulated. List the matter on
After 2 weeks.
after 2 weeks. Okay.
Obliged, Lordship.
Yes,
I will be allowed to mention item number 39.
39, okay.
In this case, instruction to appear, we all respond number 2 and 3.
As per number 2 and 3.
Yes.
Okay. All right.
Lordship, some for the petitioner.
Mm.
Lordship, in fact, in this case, there's an urgency required. Intervention of this court is required urgently, Lordship, because now the issue pertains to damage caused by the construction of 2-lane road, Lordship. Now the petitioner's house were damaged, and they are facing a involuntary displacement.
I think he has appeared today, I think. Today, no? He has to file a counter also.
Lordship, yes. Lordship, kindly allow me to apprise this honorable court that in a similar case, Lordship, there's another writ petition filed by a couple of affected landowners. At the stage of motion, Lordship, this court has issued directive, Lordship, to verify whether the claim of the petitioners are genuine, Lordship, and to also assess and file report. So, Lordship, if they're going to seek time, this is my prayer that similar,
Let me see the record and
if
see.
similar directive may be issued, Lordship.
Yes. I don't think you'll have any objection for private respondents.
For the agency.
Oh, you're for the agency. Okay, okay.
NHIDCL, Lordship.
Huh?
NHIDCL.
No, he'll definitely have objection.
Yes,
He will
Lordship.
definitely have. Let us
Now-
give him some time. You are for this, okay. National Highways. What is the full form? He will have objection.
Lordship. Lordship, in fact, this order that I just shared is pertaining to the same, arising out of the same road, two-lane road project, Lordship. So at the stage of hearing, while this court was issuing notice, this, in the last page, paragraph, Lordship, paragraph 7, Lordship, this direction was given. That's why, Lordship, it is my humble submission, if similar order can be passed, because then they can verify the genuineness, whether the claims of the petitioners are genuine or not, to the extent of, how much their properties were affected, Lordship. I'm only pressing for that.
And her prayer is not to allow the petition.
Yes,
Only to
Lordship.
the extent.
Lordship, yes.
Interim order. Oh, he hasn't. received
Lordship,
a
yes,
copy.
we have already served copy to registered AD, Lordship. We
But
have
he has
taken
not
steps.
received.
We can serve again, Lordship, no doubt.
Have you received a copy of this order?
No.
You just go through the order. I don't think she's asking for a final order.
Yes, Lordship.
Just you go through the last paragraph. We'll come back after some time.
Lordship.
I get proper instruction when we place you over very fast.
Yes,
Okay,
after a
Lordship,
week.
all
Yes.
right, Lordship.
Item number?
39, Lordship.
Learned Counsel Miss N.
Yes, Lord, and Nitya Kosa.
N. Koza is present for the petitioners. Petitioners or petitioners?
Petitioners, Lordship.
Petitioners. Learned Counsel Mr. M. Jamir, no?
Yes.
M. Jamir is present for the respondent number 2 and 3 and has submitted for time to file counter affidavit. Copies of petition to be furnished to the respondent number 2 and 3. Learned Counsel Miss.
Lordship for the state, for respondent
Okay.
4 and 5.
Learned Government Advocate Miss.
On behalf of petitioner Jim Dimson, Lordship, Pijala,
Okay. Learned Counsel, your name?
Pijala.
Pichano is present on behalf of the Learned Government Advocate. Addition, double AG?
Lordship.
On behalf of Learned double AG. List a matter after 2 weeks.
Like this, Lordship.
Mm.
Lordship, I beg to mention, I think 34, Lordship. Lordship, here, in the last occasions, we were given last chance to file affidavit, Lordship. Accordingly, the affidavit is ready, Lordship.
Mm.
However, the petitioners are from this different district, Lordship.
Mm.
So we are waiting to obtain the signatures, Lordship. So meanwhile, let the matter be fixed for admission hearing. Meanwhile, we will be filing the affidavits after 2 weeks, Lordship.
My lord, there's some urgency, so.
You fix it for admission then?
addition hearing will-
Mm.
I fix that maybe.
Mm.
Even.
Okay. Learned Counsel Mr.
Nokla M. Konyak.
Ogla.
Nokla M. Konyak.
লিখিলে পারে নামটা on behalf of Learned Counsel Mr. Sentianga
Yes, Your Lordship.
has submitted for time to file the affidavit which has already been prepared but could not be filed as the petitioners are from a remote location.
Yes, Your Lordship.
Are from a remote location, full stop. Learned Counsel Mr.
I Jamir for respondent number 7 to 70.
I. Jamir for respondent number 7 to
73.
73. has raised objection stating that this matter may be fixed for admission while the admission hearing while the affidavit is submitted, as there is some urgency in this matter. Full stop. Learned Counsel, Miss.
State.
Oh, Government Advocate. Learned Government Advocate, Miss TB.
Livika.
Okay, नाम लिख लो हाँ, Libika is present for the respondent number. How much? How many?
For the state official respondents.
For the state official respondents.
I'm appearing for respondent number 4.
And Learned Counsel, Miss Rainboni is present for respondent number 4. List
On the next day, the matter will be heard.
list this matter for admission on. You want a fixed date, no?
Manner.
When do you want? Those people has to come also from remote location and see about the roads. You have to think about the roads also.
Manner 12th of August.
12th August.
August.
Okay. 12th August.
Lordship, there is an interim.
Interim order shall continue till then.
Deeply operates.
From the supplementary cost list for motion, item number 42.
Already completed, I think. 42.
May I please the Lordship?
Hmm.
Lordship, I'm allowed to withdraw the present petition to file a fresh.
42.
Lordship.
I think there was a mention in 42.
No, Lordship, this is a supplement.
Huh? Oh, Mosh. Yeah. There's a tick mark here. I don't know why.
Hmm.
42, Naihano. Okay. There's a wrong marking here. Learned Counsel, Mr. V. Jimomi,
Lordship.
has prayed for withdrawal of this petition.
Lordship.
Okay. So, at the motion stage,
Lordship.
petition, you want any liberty?
Liberty to file a fresh.
Okay, yes. I was just asking.
Lordship.
Has prayed for withdrawal of this petition. Petition is dismissed on withdrawal with a liberty to file a fresh
File.
petition.
Obliged.
For admission item numbers 1 to 18.
Okay. 1 to 18, no? That day we took up 45 or 7, no? That day we took up one matter with similar prayer for others also.
Yes.
And which was the matter? Only one matter we have heard, but the prayers are similar.
Yes. 45 of
45. WPC 45.
Lordship.
That will suffice. I could not go through because I didn't have time also. So we can conclude, and then I will, if I may, within these days, I'll pass the judgment.
Lordship.
And if I have to ask something, I'll ask.
Lordship.
You can conclude today. Anything you have to reply or anything you have to add?
Yeah.
1 to 18, no?
1 to 18.
Okay.
Lordship, the respondent, both the respondent, the Union of India as well as the state respondent, they have completed.
Yes.
Your Lordship,
Yes, they have.
I may be, but we will make a short reply.
Mm.
My first reply to the Union, Your Lordship, Union of India. Because the council for the union is not present today,
Mm.
but the other day when he was here, he relied only on para 13 of the affidavit,
Mm.
where they have stated that so far as the teachers is concerned, it is within the domain of the state and the union territories. And then under Samagra Shiksha, on the union provide only lump sum support. That relied on para 13.
Mm.
And to that, your lordship, I have made a reply also where I've explained in detail paragraph 4 and 8, your lordship.
Yes, yes.
And also, I've relied on the judgment passed by Division Bench of Honorable High Court of Tripura, where amongst other, Section 7 of the RT Act has been examined and discussed in detail. So I'm relying on that. Now, coming to the submission made by the state
Yes.
respondent, your lordship. Now, the state respondent also relied on paragraph 11, 12, and 13 to
Yes,
their
yes.
affidavit.
Yes.
In fact, which I read out, the worship. And I've also counted the same in my reply affidavit in para 7, subpara A to subpara I. I've taken your worship to
Yes,
that,
yes.
so I will not. And your worship. Moreover, the grounds taken by the state respondent in para 11 and 12, 13 in rejecting the representation of the petitioner for mainstreaming and for grant of skill in worship, that is to be examined in my respectful submission in as per the principle of law laid down by the constitutional bench in MS Gill's case, your lordship, wherein the constitutional bench has held that the validity and legality of an order has to be examined in the light of the reason mentioned in that order, worship. And therefore, the reason given by the state respondent in 11, 12, and 13 in rejecting my representation of the petitioner, that should not be considered in the light of the principle of law laid down by the constitutional bench, your worship.
Constitutional bench judgment in which case?
That is MS Gill case,
Okay,
that which is
okay,
reported in
okay.
1978, volume 1 SCC 405, para 8, your worship.
Okay,
Now, your lordship, in her submission,
para 8, no?
lordship,
Para 8.
para 8, your lordship. Now, during her submission, your lordship, the learned additional advocate general, your lordship, has taken 2 other grounds which are not taken in the affidavit of opposition in opposing the prayer of the petitioner for still of the. So on that, I may be given just 10 minutes time, your lordship. Now, the first ground taken is that the petitioner has not challenged the OM dated 27/1/2015 issued by the Directorate of School Education notifying the
OM dated what?
OM dated 27/1/2015. That will be at page
2013.
page 123 of my writ petition.
Okay, okay, yes, yes.
By which
That notification, yes.
that fixed pay.
Uh,
So that is one ground which they have not taken the affidavit of opposition, but during the course of our submission, that ground has been advanced. Now, your lordship. Now, that notification has not been challenged. And secondly, the learned additional AG has also placed a letter from Ministry of MHRD, Ministry of Human Resources and Development, your lordship, which copy of which has not been furnished to me, stating that the union is going to stop the scheme by 2026, if I'm not mistaken. Well, I'm not informed.
yes, yes.
Now, on the first ground of worship, that not challenging that OM dated 27/1/2015, may I place before your worship just a case law passed by Honorable High Court of Worship. I'll be playing 3 case laws with the authority which I'll be relying.
Okay.
On not challenging the OM, I'm referring to 2014. To the law, page 25. This is by division bench of this honorable court of worship. 2014 to
Okay, okay.
And your lordship, this also relates to medical admission in medical college in Assam.
Oh, very good.
Right,
In Assam.
lordship.
Yes, same principle will apply here also. Mm.
May I take your lordship the para 9, that issue involved. para 9, for your lordship convenience, I have highlighted 2 lines. Para
Okay.
9, lordship has got it.
Yes.
Learned Additional Advocate General for the State of Assam submits that Rule 3.2 requires permanent residence in Assam as a condition for eligibility for admission to the MBBS. Now, next bottom highlighted, in the absence of challenge to the rules, here I have not challenged the OM. Learned single judge could not brush aside the said requirement. Now, may I take the worship to para 27? Para 27. As they have not challenged, I have not challenged the rule. Here I have not challenged the OM dated 27/1/2015.
Okay.
Lordship has got it.
Yes.
We are unable to accept the submission that merely because a specific prayer is not met in the writ petition, Article 14 of the Constitution, Lordship here is less to equal pay for equal work, discrimination, arbitrary articles of invocation.
Yes.
Would not be invoked during the course of argument. It is not a case where there is no pleading that Article 14 was violated. There is no specific prayer or plea that requirement of owning property is invalid and be quashed. Rules of pleading applicable to a writ proceedings cannot be read so rigidly as to exclude invocation of constitutional provision in appropriate cases without taking either of party by surprise. The judgment relied upon on behalf of the appellants are on individual facts and do not lay down any rigid rule contrary to this observation. The judgment relied upon certain general principle that the court has to go by pleading. There is no dispute that with the said proposition. At the same time, if parties are conscious of legal issue by hyper-technical approach, fundamental rights under Article 14 cannot be brushed aside. From the judgment of the single judge, it is clear that the parties are conscious of the issue raised. Now, next. In Ram Saurabh Gupta such and such, the object and purpose of pleading is to enable the adversary party to know the case it has to meet. In order to have a fair trial, it is imperative that the party should settle the essential materials facts so that other party may not be taken by a surprise. The pleadings, however, should receive a liberal construction. No pedantic approach should be adopted to defeat justice on hair-splitting technicalities. Sometimes pleadings are expressed in words which may not expressly make out a case in accordance with strict interpretation of law. In such a case, it is the duty of the court to ascertain the substance of pleading to determine the question. It is not desirable to place undue emphasis on form. Instead, the substance of the pleading should be considered. Now, coming to the substance, Your Worship, the issue. The petitioners are before this honorable court because they are aggrieved by the fixed fee paid to them. And therefore, they are praying for scale video. And the state government is very much aware of the grievances, the issue involved in this writ petition. Therefore, the objection taken by the learned additional AG, and that without challenging the OM dated 27/1/2015, relief cannot be given for the petitioner, Your Worship. That in my respectful submission.
So, Lanet City Jamir is now challenging the notification
Yeah,
today.
So in my respectful submission, that is not.
Okay, I got your point.
Your Worship.
Mm.
Now, even otherwise, Your Worship,
Mm.
the OM dated 27/1/2015, Your Worship, relied upon by the learned additional AG, is contrary to the provision of RTA Act, Your Worship, and law is well settled, Your
Okay.
Worship.
OM dated, what was the date?
27/1/2025,
27/1,
2015, which is at page
2016 now, 260,
2015.
2015 now.
That is at page 123 to my writ petition,
Okay,
So
okay.
just on case law on that, executive instruction cannot override certain rules. The next case I place, Your Worship.
Mm. Is contrary to constitutional rights, according to you.
Yes.
Which one?
So
Which judgment?
2007, volume 15, SEC 129.
Yes.
Lordship has got it. Now, para 12.
Yes.
Third line from the bottom. A purported policy decision issued by way of an executive instruction cannot override the statute or civil rules.
Para 12.
Third line from bottom, para 12,
Mm.
para 12, third line from bottom. A purported policy decision issued by way of executive instruction.
You are reading 2007 1 SCC 129.
2007, 15, volume 15,
Ah,
SSC
Ah.
129,
Prasanna Kumar Sahu.
para 12.
Are you sure you're reading para 12? Oh, yes, yes, yes. Last line, no?
Yes.
Mm.
Last three lines,
Ah.
last three lines. A purported policy or issued by executive instruction cannot override the statutory
Mm.
statute or statutory rules for sure.
Yes.
Now, Lordship, the second grounds
Mm.
taken and objecting to my prayer for skill pay, Your Worship,
Mm.
is that by placing a letter from MHRD.
Yes, yes.
Which
It will be stopped on
which has
in
not-
2000.
will be stopped
Copy was not given to you.
from 2026, Your
Mm.
Lordship. In here, Your Lordship,
Mm.
my submission is this. Unlike other scheme, the Samagra Shiksha, Your Lordship, I said that SSA and RMSA is now merged as this
Mm.
and stand as Samagra Shiksha. This is a flagship program to fulfill the constitutional mandate as granted under Article 21A of the Constitution of India, and which is part of the fundamental rights of the worship. Now, therefore, till such time Article 21A is deleted by way of a constitutional amendment of the worship, the fundamental right of children to free and compulsory education will remain. So also the RTA Act and rules, Your Worship. Now, even otherwise, just because the ministry union is going to stop the scheme by the year 2026.
No, they will regularize
That
actually.
does not be a ground to deny regular skill pay and allowances to the petitioner. I am on skill pay, Your Worship. Now, therefore, this is a fit case in my respectful submission when this honorable board can direct the respondent to pay skill pay and allowances to the petitioner as provided under the RTA and rules, and also the guidelines on implementation of central sponsored scheme on teachers' education. And also in the light of the judgment passed by the division bench of the Honorable High Court of Tripura, and also even by this honorable board in the Trick Appeal, Your Worship, which I placed before the. Now, next, that is on skill pay. Next, on regularization, Your Lordship, the learned additional AG has placed reliance on one case, Muhammad Abdul Qadir. That case arose out of our High Court, Your Lordship, and the matter relates to employment under prevention of infiltration of foreigners under that scheme, Your Lordship. That scheme, since its inception, it was temporary in nature. It was only for 2 years. Subsequently, it was extended, Your Lordship. Now, in that case, the Honorable Apex Court has held that at that appointment, made on schemes are normally coterminous, Your Lordship, with the scheme, and they will not be entitled to regularization. In my respectful submission, Your Lordship, that is the ratio of the judgment passed in Muhammad Abdul Qadir's case is not applicable in the present case, Your Lordship. For the reason that the service condition of the petitioners is governed by RTA and rules, and also the guidelines notification issued by MHRD, Your Worship. This is a flagship program to fulfill the constitutional mandate, and for which the Act and rules and guidelines has been framed, Your Worship.
Okay.
And as submitted, Your Worship, the RTA and rules and also the guidelines on implementation of CSS on teachers' education provides for appointment of teachers on regular and permanent basis, Your Worship. I taken to Your Worship to the rules and
Yes,
also to
yes,
the
yes.
guidelines, Your Worship.
Even the statements of objections also.
Yeah. Now, Your
Worship.
Worship, I consider that this honorable court cannot direct the state government to mainstream the service of the petitioner as was done in the case of 2,290 teachers who were also appointed under SSA and RMSA, your lordship. Now, and then to mainstream the petitioner in the cadre, state school education cadre, your lordship. But my responsible submission is that under the given facts and circumstances, your lordship, this honorable court can direct the state responsible at least to consider the case of the petitioner as per the RT Act and rules and the guidelines. Consider the case as per the rules.
Okay.
That's how we wish.
So if this direction is given, they won't have any objection, I think.
Just to consider, they can reject it, whatever, it's up to them. But so far as mainstreaming regularization is concerned,
consider the case of the petitioner.
yes, to
Petitioners.
mainstream or regularize. They can consider, they may accept, reject what, it's up to them, your lordship.
Yes, yes. There you
So-
have no objection.
So,
My leadership, I have objection
so
on that.
that much only,
So I know. That day you have argued very vigorously against mainstreaming and regulation. Okay.
I'm deeply obliged
Mm.
for patient hearing. your
Okay.
lordship. I conclude.
My leadership, just a few minutes.
Yes,
to
sure.
Rebut to what my
Yes,
fellow
yes.
friend has just stated.
Mm. Yes.
My learned friend has stated that during my course of my submission, I had gone beyond my pleadings.
Mm.
And when my pleadings have gone, it should not be taken into consideration, is what my learned friend has suggested.
Mm.
But the Supreme Court also very clearly says that when those averments or nothing rebuttion has been mentioned in the affidavit in opposition, this court has the power to consider everything, all the facts, everything taken into consideration and pass a judgment.
Mm.
And one point, my learned friend in his writ petition, he has never brought out the Right to Education Act in his pleadings in the writ petition. So when we filed our affidavit, we reply according to what he had stated in his affidavit, in his writ petition. Only in his reply, he brought out the RTE Act.
Okay.
And
That
number
is not facts, pure question of law. your lordship.
Mm.
I admitted, but I'm just clarifying.
Mm.
And on number two,
Mm.
the petitioner counsel stated that without giving the scale of pay to the petitioners, we are acting in contrary to the RTE Act guidelines and the rules.
Mm.
If at all the petitioners are appointed through a regular recruitment process, they have the right to question or say, but they are still on an ad hoc basis. Their appointment itself is also in contrary to the rules, the acts, and the guidelines. So the petitioner cannot claim for a negative
Okay.
quality. Then with regard to the mainstreaming and the regularization, their lordship, their post is a centrally sponsored scheme. So to mainstream them to the state, it is the discretion of the government, and this court cannot direct the government even to consider for mainstreaming or for regularization. That's my humble submission.
Okay. We'll conclude then. Heard learned counsel Mr.
TB Jamil.
TB Jamir for the petitioners, both petitioners, 180. Learned government advocate Mr. Miss B. Supreme. Learned double AG, Miss B. Supreme.
And Livika.
And Lipika for the state
states.
respondents. And anybody else? No, no?
Younger, what is CGSU?
Okay, Sentiangar.
C Central.
And Learned Council, Learned CGC, Mr. Sentiangar. Yangarwati. I forgot who was there last time. Mr. Yangarwati. For whom? Oh, CGC. Okay, for UI. Reserve for Judgment and Order. So I'll try to finish it here itself during my stay.
Much better.
For admission, item numbers 19 to 33.
That day, no?
Yes, madam.
That day, okay. So I have heard you, and then there's only one point I'm sticking to. That same thing, no? That there are the rules, then but they did not follow the rules, and then they did not give you 1 month's notice. So you want the order to be set aside.
Yes.
And
That is my prayer. And another prayer is that by this honorable court, the respondent was directed to pay my back loan.
No, that he will pay.
Yes.
He has no objection.
Yes.
Only the setting aside, he has raised objection. So that day I couldn't conclude because he has raised serious objection, so I couldn't conclude. Otherwise, if he didn't raise any objection, hadn't he raised any objection, I was more inclined to allow the petition. So let's see if he has,
Should they kindly see my authority?
if he can substantiate his objection.
Gauhati Law Times,
Hmm.
the Lordship. 2017, column 2, page 490.
So there are many petitioners according to him, then it will create a chaos
940.
and it will affect the exchequer also.
940.
Yes, what aspirity is
Mm.
fencing.
It will affect the
940.
exchequer and then
But when there is a legality,
illegality that can be set aside. Okay.
940.
I'll need a printout. And then that day he has also referred to several judgments from the book. But Albert was there. I didn't get any printout, huh? Huh? Oh, you are Albert, no? Yes, yes. Lima was there. Lima was there, so he didn't give me the printout of those judgments. I didn't. You can ask him. There are 3 books. I think Jamir, last advocate, last case, Advocate Jamir. He has given 3 books. GLT, SCC, 3 SCC, but printout was supposed to be taken out.
Page 940, your Lordship.
Page 940, yes.
Meghalaya High Court.
Mm. Mm.
It is decided on 15/12/2016.
Mm.
Service law. May I read your Lordship?
Yes, yes.
Service law, termination from contractual service, legality and validity thereof. Held.
Mm.
An employee appointed on temporary basis is not governed by any service rules, and he is bound by the terms and conditions incorporated in the appointment letter.
Oh.
It is a civil legal preposition that the person whose appointment is purely contractual and temporary in terms of the conditions stipulated in terms and conditions of his appointment. That he can be summarily discharged due to unsatisfactory performance. That is that. Those, I'll take you to the Bara 20, 21, and 22. Next page.
Mm.
Next page.
Mm.
Para 20.
Mm.
Admittedly, an employee appointed on temporary basis is not governed by any service rules, and he is bound by the terms and conditions incorporated in the appointment letter. It is a settled legal proposition that a person whose appointment is purely contractual and temporary, while the conditions stipulated in terms of the conditions of its appointment, that he can be summarily discharged due to unsatisfactory performance and misconduct of any kind, does not have a right to claim any relief if his services are terminated in terms thereof.
Okay.
Lordship, next, 21, the Honorable Supreme Court, in the case of so and so, has categorically held under the service jurisprudence a temporary employee has no right to hold the post and his service are liable to be terminated and in accordance with the relevant service rules and in terms of the contract of service. 22. It is civil law that a temporary employee has no right to hold the post in his service are liable to be terminated without assigning any reason, either in terms of the contract providing for such termination or under the relevant statutory rules regulating the terms and conditions of a temporary servant. A similar question come up for consideration in the case of Your Lordship. These are all of the apex court, not last para, supra. And the Supreme Court has categorically held that an incumbent to a post who has been given appointment on temporary basis terminable without notice has no right to hold the post and he is not entitled for any opportunity of hearing before his services are dispensed with, as his termination does not amount to forfeiture of any legal right. So, Your Ladyship, the apex court has made this decision in a container of cases. As I said, on the day of the argument, the contractual, the employment of the petitioner is very clear.
Yes.
Is very clear.
Yeah.
Is very clear.
Mm.
Can be terminated without any notice,
Yes.
anytime.
That
So-
day you have brought to my notice.
Yes, and this has been affirmed by this
Judgment.
decisions of the apex court.
Yes. Right.
That is termination part. And so far as payment of the arrears has been concerned, Your Ladyship may pass with and pass any order.
Yes.
For that, I have no objection because once an employee
That
has
day
served,
itself we were not raising any objection.
once an employee has served,
Mm.
then particular employee has a right to apply for his services. That is constitutional scheme. So I have nothing to say on that. I'm willing to carry out that.
Mm.
Lord,
See, he has a point.
my lord, I'll make a submission in reference to that termination.
Judgment.
Now, the question here I'm challenging is based on the termination order.
Mm.
And then in the termination order itself, I'm saying that it's illegal, arbitrary. Why? Because he has specifically mentioned that Rule 5 of CCSTS.
Yes, yes, that day you have stated.
So when it is illegal,
Mm.
it may be.
He still has a point, you see.
It may be applicable.
He still has a point.
It may be applicable, but we have
I'm aware of that. I'm aware of that. Your
I
Ladyship
have
is,
some authority also.
Your Ladyship is very much well aware.
Mm.
The executive people, the bureaucracy, the bureaucratic people are not legal experts.
No, but they have mentioned the rules, so then they have violated the rules. When they have mentioned the rules, they have violated.
No excuse, of
Yes,
course.
exactly.
Of course, that is a maximum that is there. But I may say, because of a burden clerical error, he might have put that. Otherwise, when the woman itself says no notice is required,
If the state response really want to terminate.
when the appointment order is explicitly very clear that no notice is required, and the petitioner is aware of that, why should he come to that small technical mistake? Now, petitioner has no right to climb. That's why he's coming to the technical aspect. He's trying to change the course by availing technical mistake, by projecting a technical mistake as a mistake in law, which is not acceptable.
Lordship, by that order itself, I was terminated. So making a submission that a technical or error is not substantiable. That is first point. Second point, I have one authority, so I would like to place before Supreme Court.
Mm.
That is 2003 Supreme Court,
Yes.
SCC 239. 239. The relevant para will be 6, 7, and 8.
Just a moment, I'll note down this. I'll need the
2003 SSC 239. Then the relevant para is 6, 7, and 8. I may be allowed to read.
You have read out, just a moment, you have read out which paragraphs? 20, 21?
Yes, 2021 and 22. 2021 and 22. Your Lordship, you will find the decision of the apex court in para
Yes,
22.
yes. I'll need a printout of this one. And then yours is
2000 S3 SSC 239. So it deals with whether proper due process or proper opportunity of natural justice has been given or not. Here the question of law is.
which paragraph?
Paragraph 6, 7, 8. 3 paragraph. It is
Okay.
very related and relevant.
Mm.
I may be allowed to.
Yes.
Letter counsel for the respondent has contended that the appellant, after appointment, was placed on probation, and throughout the period of probation was 2 years. His service could be terminated at any time during the period of probation without any notice as set out in the appointment order, letter. It is contended that the appellant cannot claim any right on the post of which he was appointed and being on probation. His work and conduct was all along under scrutiny, and since his work was not satisfactory, his service were terminated in terms of conditions set out in appointment order. The plea cannot be accepted. 7. A probationary like temporary servant, this is important, is also entitled to certain protection, and his service cannot be terminated arbitrarily, nor can those services be terminated in a punitive manner without complying with the principle of natural justice. Number 8, the affidavit filed by the parties before the High Court, as also in this court, indicates the background in which the order terminating the service of the appellant came to be passed. Such an order, which on the face of it is stigmatic, could not have been passed without holding a regular inquiry or giving an opportunity of hearing to the appellant. So, my ladyship, in this particular case,
So there are similar cases, there are contradictory cases.
so many.
He has
so many-
referred to the Supreme Court contradictory, it will be division bench.
Yes.
So,
And then my humble submission is there.
so
the-
which one must I follow if there are contradictory decisions?
Look, you know, this is the standing of the board, the apex court. Because
Yes,
see,
he has referred to apex court
but
decisions.
my humble submission. See, if they really want to, I'm coming to that. If they really want to terminate us, take them a due process. I don't have any objection.
Mm.
But see, rather on the behind the back, if we see the order, there are so many arbitrariness, and then the manufacturing at the same time illegal, because till September they have issued me the termination order. August they have signed in the order. Effective date 1st January. That is behind the back. And then after that, the order itself is very illegal. And then if they really want to modify, if they really want to take action, let them take as per the due process of law, as per the rule, as they have got it in the termination order. So unless and until this termination order is modified or doesn't as they wish, this present impugn order cannot be sustained in law. That is my whole submission.
I only want to ask that there are contradictory. He has referred to so many Supreme Court judgments. I've closed the page. Okay, so he has referred to so many, I want the printout of this also.
And then even the latest Supreme Court, we have reaffirmed for this giving natural justice, opportunity of being heard in so many several cases.
Wait. These are, of course, before this judgment. This Supreme Court orders he has referred to, our last is 1995. So yours is 2000.
Yes.
So later judgment cannot, this is not the principle that the later judgment has to be accepted. But which judgment has to be accepted?
That I leave it to the lordship, but my humble submission is that the termination order as on this condition cannot be sustained in law. That is my humble submission. That is
So
the-
all the judgments referred to in by the government advocate are older Supreme Court judgments. And yours is, which judgment holds the field now?
I leave it to the lordship.
Your lordship, please appreciate why petitioners were terminated. You were terminated you were appointed for a certain purpose only. And now the purpose has been done away with. So there is no funding. It is because of that reason you were terminated. That is.
It is not stating the termination.
No.
No, you see, he has a prayer
No.
also.
How
He-
you were terminated? You were terminated because of the exhaustion of the scheme or the money in which they were.
That is what
given the
that is
wages.
what he is submitting. He is saying that this order may be set aside. This order, last order may be set aside, termination order. And then you can terminate in accordance with law.
That is my answer.
That is what he is saying.
I'm just brings the relevancy.
Termination order was issued on 8 August 2024. 8 August 2024.
Nine.
Uh,
Manifest. Manifest.
9 August 2024.
Mm.
If my learned friend is very passionate about the principles of natural justice, which is enshrined under 311 of the Constitution of India, then Lordship may allow us to issue notice to them and terminate them.
That is not a subject matter in this petition.
Because, you see, to bring them back to the work, as your leadership has very vividly understood, it's impossible. Because we have to pay, government has to pay. Since the scheme under which you were appointed has been exhausted, this is practice all over India. Work charge casual are appointed for a specific period to execute certain work.
Yes.
When the work is over, then it has to be, that is understandable by in the work order itself.
Yes.
No notice is when nothing is required. But if my friend, learned friend, insists on principle of natural justice, which is enshrined under 311 of the Constitution, then in that case, allow us to notice and terminate.
Lordship, here in this present petition, that is not actually I'm against the illegality how they have taken these steps. And then see, I'm saying that we all are work charge employee in the state of Nagaland. And then in the other department also, several work charges are there. And then the government has given several notification. And then I'm working for more than 28 years. And then the Apex Court has observed that if a person is allowed to continue in civil for many years, he cannot be even treated as a temporary service. That is also I haven't stated, observed by the Apex Court. But I'm not going up to that extent. But my simple humble submission is that, see, we have given illegal order. So the legal order go with if they really want to take some steps, it should be in a proper way.
Okay, my other question is, all the petitioners, they were terminated on the same day?
Same with the common order.
Or with a common order,
Yes.
same day?
Yes, and then as I say, this
They were appointed on different dates,
different dates,
Ah.
but
terminated on the same
and
day.
that also on the consumption, the malafati also. Not only illegally, but malafati is there. This I have approached this honorable board for asking for my backlog wages. But when we are considering my salary, he have paid, he have issued circular behind the back, not giving the information to me, and then they have given me 22 months. And then the way he have treated the petitioner, on the day of giving 22 months, he have given me a present by termination order. That also behind the back, and then illegally. So that is the whole submission. I'll leave it to the motion.
So that first petition was 45, no? You were discussing, 7, WPC 7, no? WPC 270,
266.
266. So we are discussing 266, and thereafter all the petitions have the same, they were terminated on the same day.
Department.
Tenure of service is different.
Yes, nature of the report.
Nature of work and tenure of service is different.
Yes, that's not whole concept.
Your leadership,
Mm.
one point.
Yes, yes.
By the order of 9 August 2024,
Mm. Yes.
similarly situated persons were 25.
Mm.
The 25 persons were terminated in different capacities.
Mm.
Only 15 of them has approached this court by way of this writ petition.
Mm.
So 10 has not approached this court.
Mm.
Only 15 has approached this court.
Mm.
Because terminated employee were 25.
Okay. Out of 25, only 15 have approached this court.
Yeah.
Okay. If possible, I'll complete and pass the order today. You keep this only with 266. It has been kept with all the arguments and everything has been kept with 266. This also. That day I have dictated the order of 266, so I'll, if I possible, I'll complete and pass an order today. This to be returned.
For admission, item number 35.
25? 35. Okay. Hmm? Yes, yes. Oh. Yes.
Your Lordship, in this matter, the respondent has not filed a affidavit till now. They just.
Oh, that they have stated that they will file affidavit or
Yeah.
something. Yeah, okay. I passed an interim order also, no?
No, that's some other one. That is the.
Oh, interim order has already been passed. Okay.
This some other. They are also again the bank saying
So we'll continue the interim order.
interim order in your Lordship. Interim order, let it be listed on 11th of
11th of
September.
September, okay.
And the last chance opportunity.
Yes, yes.
Last of and
Oh, here he is.
Lordship, we are yet to file our affidavit. We have filed our affidavit.
You have filed your affidavit.
no. You have not filed it. We have not filed it. That's why I told that here MLA not have to time.
Okay. Learned Counsel Mr. P. Chaudhary is present for the petitioner. Learned Counsel Mr. P. Forte is present for the respondent, has submitted that affidavit has not been filed. A last opportunity is accorded to the respondents to submit their affidavit, list the matter on 11th September. Okay. Interim order shall remain in force till then.
For admission, item number 36.
This is also against the bank, but it's a different matter.
Same.
No, here, as well as I have some problem here. Here, what other place, let me tell the matter. Your Lordship, this is a case of corporate loan, Your Lordship. There are two types of loan. One loan is taken against mortgage, that is term loan, which is secured by mortgage and the interest rate. And another is OD loan backed by FDR security, liquid security, which is covering the entire. In the present case, it is a subsequent one. What has happened, Your Lordship? The petitioner, the respondent has kept lot of FDS as collateral security. They are not furnishing us the details what are the security they have given, because I have lot of FDS in that bank. They have collected and they have not given what is the collateral security they have taken, a list of FDS and the value of that. This I require. Then secondly, how many FDS they have encashed pursuant to this. This amount I require so that I can make a finalize of the whole thing, Your Lordship. This I have given RTI, I have given, they have not responded to. So Your Lordship, I direct that I have applied for, let them furnish these documents to me. The bank directly, Your Lordship.
Worship here also the same. We have filed only our one document.
No, this is something else. This is the bank, security, that is the bank, not it. It is that security what I need the list of the FDRs which they have kept as security, coded security, and their present value, because the FDRs value, and secondly, the list of FDRs which they have encashed pursuant to this law. This they were punished in a week's time for by the bank to meet the petitioner here also. So that,
Have you encashed
but they have encashed.
all the securities?
Maybe, just give us some time.
Okay.
We'll find by the date.
So
We have
this is-
received the certificate a few days back, but there was some defects, so we have to send back.
Okay.
And since it's a bank, we have to get approval from the regional. So we have to send it to Gauhati.
Yeah.
So kindly give us at least 3 weeks.
No,
so that in
I'm
time.
not arguing. I'm saying this because this is the problem with me because my money is getting blocked. I don't know what I have been going to the bank. They are not furnishing me these things. I don't know how many FDS have been they have kept. So I want a list of FDS which they have kept at collateral security with the present value. And secondly, the list of FDS which they have encashed as encashed towards this corporate loan.
Okay.
This and they furnish me in period of one in the bank to furnish to me.
Regarding the
Encashment.
encashment,
Yes.
to get
No, that bank. I'm saying a direction. If there's no encashment, they say no encashment. I am asking the information from they are not furnishing this. That's why I'm handicapped here. I don't know how much money they have. I'm totally in dark. Because here I am asking a simple thing: the list of FDR which have kept as collateral security for the loan. Secondly, I have asked how many FDR, if any, they have encashed. Give me the list of that available. That's two simple things. That bank can furnish it. There's no question of affidavit in that regard. Bank can furnish.
But this is the security you have given. They can encash it and they
No,
can.
that's why I wonder what they have encashed. I should know also, no. I'm not saying that they are not, let them encash it, but question, I should know how much they have encashed. Because what has happened, here the bank has admitted they have taken 30 lakhs excess from my this thing. The letter is there.
From the security?
From the account, yes, they have security. If you lordship see page 82, they will be at page 82, their own letter.
Okay, it's okay. I understand.
Yes.
They have accepted that they have encashed.
Yes, I'm not, see, if they say they are no and nothing has been done, they have to get that in writing. No, that's a simple thing.
Yes, I think so.
I'm not asking for anything. If they have encashed, fine. They have not encashed, they said, I will not encashed any of the FDRs. Let them say so.
But this will be taken up at the stage of argument, I think.
No, this is because that will help us to know what is the amount. We are not able to know what is the amount. As a reader, we cannot proceed the matter. If you don't know the amount, how to, because
No, what you have taken loan and you have not repaid the loan.
Yes.
So what is there? You'll as it is, you'll have to proceed with the matter.
No. See, your lordship, here what happened? The security is much more than the loan which they are having. The FDRs which are having are much more than the loan which they have taken here. And we have asked them to close down, they have not closed down. That will go to legal system. But what I am saying here, at this stage, if they get, I want this information. How many FPR they have?
But this is a matter of argument, you see.
No, it's, not that. I asked, you're not, what time you're, I'm not.
Yeah, no.
I make
It
myself.
will not be on asking. You'll have to file an IA. It will not be on asking.
That I.
Mm.
Well, that's a sense because the bank is to give to it, not that's all.
Yes. Which bank?
No, Indian bank. You're not, I'm not.
Indian bank.
Yes, you're not. That issue, I think I'm not clear what I'm saying.
Mm.
What I'm saying, your lordship, when I want this information from it, these are the things, these are the suppose FD I have.
I understand.
And
Very
if you are
clearly I
clear,
can
so
understand.
that I can go, what is the amount? Then I can proceed, your lordship. Because now I cannot proceed anything, your lordship.
So it has to be through an application, I think.
Because that can be given, you know, so that is so problem.
No, because this will be taken up for argument also. This money borrowed and the security deposited, these are the main issues in this WPC. The amount of money borrowed, and according to you, yes, there can be some banks who may encash.
I'm not on encash. I'm not on encash. I want original information. What are the FDR they have encash? That's only it. Only the FDR they have encash. That's all. If they have not encash, there is no encashment. This information I require, your lordship. Nothing more than that. I'm not saying that.
I'm certain you'll have to file an affidavit and they'll have to give the reply. Affidavit or any interlocutory application, and they'll give the reply. Learned Counsel Mr. P. Chaudhary is present for the petitioner and has submitted. Okay, then this may not be brought on record.
Yeah.
Next day you try to convince some other bench.
No.
When I'm not around.
If I had your lordship.
No, it's okay.
I'm not a bench hunting your lordship.
No, it's okay. I'll just keep it for your convenience. I'll keep it aside, and you can file an IA, or if you want to, if you don't want to, it's up to you. Learned Counsel Mr. P. Foseko, no?
Yes, Foseko.
Is present for the respondents and has submitted for time to file.
Opposition.
Huh?
Affidavit in opposition.
To file the affidavit in opposition. Full stop, then last chance. Okay. A last chance is accorded to file affidavit in opposition. List the matter on 11 September. Interim order shall remain in force till then. Oh, time is. Matters are over or matters are over.
Yeah, matters get over very fast.
Really?
I want CAV.
Today. 지역 문화만 이제 하나 혹시
Oh, yes, sometimes next week. Okay, now we. You have to walk out. Okay, yeah. Yeah, Yes.
This was what I also the budget pro or movie education. Creative good as. Hello.